Sorry, Judge, I just had to find my place. Um, Detective Leary, Miss Miss Behringer never said anything about Mr. Turner hitting her, did she?
Stated that she was shaking and she hit her head.
So, but specifically hitting, like, I mean, punching, slapping, kicking, that sort of thing. Miss Behringer never said that, Mr. Turner hit her.
I don't recall verbatim what she stated word for word.
Do you remember her saying that she had hit him?
I do not recall verbatim word for word.
You asked her how she got the nosebleed, and she pointed at the bed and said that she had hit her head on the mattress. Is that accurate?
I do not recall verbatim word for word what she stated.
All right, now I guess let's get to these marks. After speaking with Ms. Behringer, you immediately went out in the hall and arrested Mr. Turner. Is that fair to say?
I did detain him.
Okay. When you say detain, you immediately put the handcuffs on him, right?
Correct, because he's not free to leave.
And you did not advise him of his Miranda rights after you put handcuffs on him. Is that fair to say?
I do not if he's not being questioned.
Okay. If he's not being questioned, right? But then after putting him in handcuffs, you say to him, in the state of Georgia, you cannot put your hands on someone and think it's all right. And then Mr. Turner started to shake his head no. And in response to that, you said, you can say that you didn't, but she have marks. It tells me otherwise. She's a light-skinned female. You remember that?
Yes, sir.
Okay. And Mr. Turner responded to that statement that you made by asking you, he said, ain't no marks on me. So he's asking you a question. Ain't no marks on me. Do you remember that?
I don't recall that verbatim what he stated.
Would it help if I refreshed your recollection?
Yes.
Let's see if we can hear this. All right, I'm referring back to your video, Detective Leary, and I'm going to go ahead and start at approximately 8 minutes and 31 seconds.
Otherwise, she's a light skinned female. She got ain't no mark.
Were you able to hear that?
I heard him. I heard me. I didn't hear him when he said it.
Permission to approach the witness, Judge?
Your permission granted.
Otherwise, She's a light skinned female. She got random marks. I don't know.
So I'll ask you again, Detective. So you're talking about the marks on Miss Behringer. And Mr. Turner says, ain't no marks on me. Is that what you heard on the recording there?
Yes,
Okay. And your response when he said that was, I don't know, right?
because he's not asking me a question. Did I see marks on him?
So I think we already covered that Mr. Turner, he's wearing a sweater, right? He's got pants on. Okay, so obviously you can't see his arms, you can't see his torso or anything at that point, right?
Yeah, he never made a statement that I'm injured as well.
Did you, since he indicated that there might be marks on him, at this point, did you conduct any investigation into where those marks might be on his body?
I did not, because he would have to be read Miranda at that point in time.
So it's fair to say that despite being invited to do so, you did not look for marks on Mr. Turner's body.
Correct.
Now, Mr. Turner, in response to the accusations that you made in the hallway toward him, he said, I didn't put my hands on her. He told you that, right?
Yes,
And you asked what you call it. So you ask him, like, what do you call it? Okay. Is that accurate? You asked him what you call it.
yes, I did make that statement.
And he said, I'm just telling you, man, I didn't put my hands on her. I didn't. I was just trying to leave. Do you remember that?
I don't remember those exact statements verbatim.
Can I refresh your recollection again?
If you would like,
Make sure the volume's all the way up.
What you call it?
So that was you saying what you call it.
well, I can tell if that was me or him speaking right there, because I just heard.
Okay.
Call it.
So I don't know what's being said for me to even make that statement on what you call it, because I can't physically hear.
What you call it? Call it.
Me.
What you call it?
He says he can't tell who it is, so we'll just let's move forward.
Do you remember asking him, do you remember asking Mr. Turner, so why you didn't leave? You remember asking him that, why you didn't leave?
Yes,
And he said to you, she got in the way. Do you remember that?
I don't recall verbatim on what he stated.
Do you remember then saying to him, and you moved her too? Do you remember telling that to Mr. Turner?
I remember making the statement.
And then Mr. Turner says to you, I just tried to help her out of the way. I didn't pick her up. I didn't hurt her. Do you remember that?
I don't recall his statement as verbatim.
Now, detective, you gotta. Now, detective, it's fair to say that prior to putting the cuffs on Mr. Turner, you hadn't asked him a single question, right?
Correct.
Okay. You stood out in that hall with him for quite a few minutes though, right? While Sergeant Smith was inside talking to Ms. Behringer again?
Yes.
Okay. No, you didn't author a report or anything in response to this incident. Sergeant Smith authored the report, right?
Correct.
Okay. Did Mr. Turner smell of alcohol to you?
I don't recall what he smelled like on that day.
Did you observe any signs of impairment in Mr. Turner? Did he appear impaired to you?
I don't recall. Was different impairments for different things, different signs are shown, but I don't recall his impairment on that day.
All right, I have no further questions, Detective.
All right, thank you. Ms. Wardrop, any cross?
Yes, Judge. Detective Leary, good afternoon. Um, At the time, you were working for East Point Police Department, correct?
Yes, ma'am.
And what specifically was her title there?
A corporal as a patrol officer
Okay, and what were your duties as a corporal for East Point Police?
to enforce city, state, federal law and patrol the jurisdiction of the city of East Point.
Okay. And do you respond to 911 calls?
Yes, ma'am, I do.
Okay. And as part of your response, did you then investigate the calls that you responded to?
Yes, ma'am.
Okay. And did you have an opportunity prior to March 14, 2019 to respond to domestic violence calls?
Yes, ma'am, I have.
And had you had the opportunity to investigate those types of calls?
Yes, ma'am.
Okay. And can you tell me again what your investigation entails when investigating that type of a call?
So dealing with domestic violence from previous experience that some victims are scared of their attackers and they're reluctant to speak with officers at the time when they're first initially on scene. Sometimes they may forget things. Sometimes they may omit things because the attacker is around or near.
Okay. And you were not the first officer to respond to this particular scene, is that correct?
Correct.
Okay, that was Officer Smith?
Yes.
Okay. But you did end up coming onto the scene, and what was your role once you got there?
I was told to go into the room and speak with the female victim.
Okay. And was her name Casey Behringer?
Yes, ma'am.
Okay. And in speaking with Ms. Behringer, she indicated to you that, did she indicate to you that the defendant had assaulted her?
Yes, ma'am.
Okay. And what was her demeanor in speaking with her?
She seemed scared. She was seemed like she was in shock.
Okay. Was she reticent or reluctant at all to speak with you?
She was reluctant to speak to me at first until I continued to ask.
Okay. And were you privy to any conversation that she had had with Officer Smith prior to your arrival?
No, ma'am, I was not.
Okay. And when you spoke with her, what did you notice about her physical appearance?
I noticed that she had a white towel around her upper body. I could see red markings on her arms. I think if I recall, I remember seeing red markings on her chest as well.
Okay. And so did she tell you what had caused those markings?
She stated that Mr. Turner had did because he had shaken her.
Okay. And did you notice any bleeding at all?
I can't recall about bleeding or seeing any blood.
Okay. And when you spoke with Ms. Behringer, who was in the room with you and her when you spoke with her?
It was just me and her.
Okay. Was the door open or closed?
It's to my back. If I recall, the door was cracked.
Okay, all right. And what did you do after you spoke with Ms. Behringer?
I went out to the hallway where Mr. Turner was and Officer Smith and placed Mr. Turner into handcuffs.
Okay. Were you privy to the conversation that occurred between Officer Smith and the defendant?
No, ma'am, I was not.
Okay. All right. You stated there were how many exits in this particular room?
Two.
Okay. And to your recollection, did the defendant ever tell you that Ms. Behringer would not let him leave the hotel room?
I don't recall that verbatim.
Okay. And to your knowledge and recollection, did Ms. Behringer state to you that she didn't want the defendant to leave?
I recall her stating that she wanted to be by herself.
Okay. So she stated she didn't want to be by herself, but did she ever state to you that the defendant could not leave?
No,
Okay. Did she ever state to you that she was preventing the defendant from leaving?
no,
Okay. Did you find any probable cause whatsoever on which to charge Ms. Behringer with a crime?
no, ma'am.
Did you find any probable cause on which to charge her with false imprisonment specifically?
No, ma'am.
Did the defendant make any affirmative effort to show you any markings on his person?
No, ma'am, he did not.
Did he make an effort to tell you where they were located?
No, ma'am, he did not.
And did the defendant only make these claims of injury after you had put him in handcuffs?
Correct.
Did you tell the defendant at all about your conversation with Ms. Behringer
No, ma'am.
and what she stated to you?
No, ma'am.
But I heard when the defense counsel was asking you questions, the defendant stated to you, "I didn't pick her up." Is that correct?
Yes,
Okay. But at that point, you had not told him anything about what
correct.
he had said. Is that correct?
Correct.
How long did your investigation, on-scene investigation last approximately?
It was a couple moments for speaking with the victim and looking at her bruises.
Okay. Do you recall about how long?
Not meaning-wise, I don't.
Okay. Do you know how long it is that the defendant was outside of the room with Officer Smith?
It was maybe a couple minutes.
Couple of minutes? Okay. Do you know if there was anyone else outside the room with Officer Smith and the defendant when they were speaking to each other?
If I recall, the security also was still out there.
Okay. But the security officer was not asking the defendant any questions, correct?
Not that I'm aware of.
Okay. And when you heard the defendant say, "Ain't no marks on me," you took that as a statement?
It's him implying that I'm not injured.
Okay. Nothing further, Judge.
All right, any brief, very brief recross or redirect, I guess.
Yes, Judge. So, detective, so victims are sometimes reluctant to speak with officers, right?
Yes, I'm not understanding your question.
No, that's my question.
Oh,
Are
it's a
victims,
statement.
victims of domestic violence are sometimes reluctant to speak with officers. I think that's what you said on cross-examination there.
From previous experience.
Okay, all right. And then you also mentioned, as prosecution asked you the question that you know, Mr. Turner, he didn't complain of injury until after you had put the cuffs on him, right?
Correct.
Okay, so he didn't speak up prior to that and say, I'm injured, right?
That I'm aware of.
Okay. And, you know, that he took no affirmative effort to show you the markings on his body. Is that right?
Correct.
Okay. All right. So he was reluctant. He was reluctant to do that.
Yeah, he was reluctant to say I'm not injured.
Okay. Now, I just want to point out that you hadn't talked to him at all. You hadn't said one word to him until after you put the cuffs on him, right?
Correct.
Okay. So he's got cuffs on. So you've already made the decision. He's going to jail, right?
I made the decision that he was going to be detained. I did make the decision. Yes.
And he's at that point, he's supposed to show you these markings on his body. Well, you got handcuffs on him.
If you're injured from previous experience, people have said my right arm is injured, my left arm.
Well, he did complain about the cuffs being too tight, right?
But that was not from an injury that he sustained with the victim.
But you just said victims are reluctant to speak with officers.
But the cuffs being tight has nothing to do with injuries from being involved in a fight with a victim.
Okay. So the standard applies to Miss Behringer, but not to Mr. Turner, right? He's
In your words, yes.
not a victim. You knew that when you walked out.
In your
right?
words.
And so I just want to make sure that I understand that your testimony on cross-examination here, that you're now saying that after you said to him, in the state of Georgia, you cannot put your hands on someone and think it's all right. You can say that you didn't, but she have marks. It tells me otherwise. She's a light-skinned female. And when he says to you, ain't no marks on me, you're telling the court here today that you took that as a statement that he didn't have any marks on him? That wasn't a question?
I didn't ask him a question. He made a statement.
It's your testimony. That's a statement. That wasn't a question.
Correct.
I have no further question.
All right.
Your
thank
Honor,
you.
just briefly, if I just may,
Oh, is it absolutely necessary, Ms. Waldrop? I think I have the flavor of this.
it'll be very brief.
All right, very briefly.
I just want to establish, the defendant wasn't reluctant when he told you he didn't have any marks on him, right?
Correct.
And he wasn't reluctant when he told you I didn't pick her up, right?
Correct.
Okay. And this was a preliminary investigation that you were conducting, is that correct?
Correct.
Okay, and you didn't affirmatively ask the defendant questions what he stated to you were statements that he made. Is that correct?
Correct,
Of his own volition?
correct.
Okay, nothing further, Judge.
All right. Thank you, Detective Larry. Appreciate you coming to court today, all right?
Yes, ma'am. Have a
I
nice
think you
evening.
can be excused.
Thank you.
All right, Mr. Cornell, do you intend to call the other officer up?
I do, Judge.
All right, let's go ahead and do that.
Sergeant Smith. Thank you.
Is that the final witness? And then we'll do closings? Matthew,
I may call Mr. Turner on rebuttal, Judge.
is that absolutely necessary? Like I said, I think I have a very clear picture of what's happened here throughout. And if he's just gonna come back and undo what has already been said, and if you feel that that needs to be added, I'll allow a very brief rebuttal. But I really do feel that I understand this case in its entirety. So I'll give you about 10 to 15 minutes for Mr. Turner to be a rebuttal witness if necessary. But Officer Smith, I'm sorry, please give me your proper title.
It would be Officer Smith.
It's Officer Smith. Officer Smith, if you would come to the podium so that you can be sworn in. And again, this is,
Do you swear affirm testimony about giving the case to be the truth, the whole truth, and nothing but the truth?
I do.
all right, Mr. Cornell, please proceed.
Good afternoon, Officer Smith. We're here today about the arrest of Mr. Turner that was made on March 14th, 2019. Remember that arrest?
Yes,
And you authored a report subsequent to that arrest?
yes,
Now, I noticed from the video footage that you were the first officer to arrive on the scene. Is that accurate?
that is accurate.
And you went into the room to speak with Ms. Behringer while Mr. Turner stood in the hallway. Is that accurate?
Yes, that would be accurate to my recollection, yes.
And then Corporal Leary arrived, who's now Detective Leary. Is that accurate?
He's now, yes, correct.
And Corporal Leary then stepped into the room, and you stepped out of the room and stood outside with Mr. Turner. Is that accurate?
Yes,
And Corporal Leary was inside the room. He went inside the room to question Ms. Behringer. Is that accurate?
that is accurate, yes.
Now, when you switched out, or prior to switching out, Ms. Behringer hadn't. Is it fair to say that Ms. Behringer hadn't really told you anything? Is that fair to say?
At the time, that would be fair, yes.
Okay, and I think you told Corporal Leary, she said they were just arguing and there was no physical contact. Do you remember that?
I believe, well, I don't know the exact words, but maybe something to that effect. Yeah, so I couldn't say exactly what I said.
Now, did you had your body cam operable at this time?
Yes,
Okay. And would you recognize your body cam footage if I showed it to you?
yes.
Permission to approach the witness, Judge.
Permission to approach. Granted.
First name. What's your date of birth?
If you're in proximity and my voice, yeah, I would say that was my body cam.
Okay, and that's Ms. Behringer in the still there?
Yes, sir.
All right, Judge, I'll move to admit, I'm not sure what plaintiff's exhibit that'll be, but all of the videos are going to be contained on one disc.
I know you're requesting the admission for the purposes of this motions hearing. We're allowing the testimony to be admitted just for the recollection and refreshing, all right? As we previously agreed. So let's move forward with questioning.
All right, and so after you guys swap out, a few minutes later, Corporal Leary comes out and places Mr. Turner in handcuffs. Is that accurate?
To my recollection, yes.
Okay. And once he places Mr. Turner in handcuffs, then you go back into the room to further question Ms. Behringer.
Yes, sir.
Okay. And when you get back into the room, Corporal Leary hasn't really told you at this point why he arrested Mr. Turner. Is that fair to say?
I don't recall exactly. I know in transition, he may have said, something to the effect of, get the actual story from her, and he may have given me a portion of that.
Okay. But when you get back in the room, you start questioning Miss Behringer. Is that fair to say?
Yes.
Okay. And she specifically tells you that Mr. Turner did not hit her.
I don't know the exact words that were stated at the time, so.
You asked her about nosebleed,
Mhm.
and she pointed to the bed and said he didn't hit me. Do you remember that?
I don't remember verbatim, but I do remember going back in and questioning her and some of the actual, the evidence, the blood and the nosebleed and everything. Yes, I'm certain that I did ask her about it, but exact verbiage I couldn't exactly say. So
If she had indicated that Mr. Turner had hit her, would you have documented that in your report?
most likely, yes, sir.
Right. And did you document any statement from Ms. Behringer that Mr. Turner had hit her?
Of being struck, no, sir.
Now, Ms. Behringer did say that something about Mr. Turner wouldn't give her the key card. And then she said, because I didn't want him to leave, because then I would have to go down and get it. Do you remember her saying that she didn't want him to leave?
I can't say that I remember verbatim, any of the actual conversation. Most of what I documented would be, the recollection and the pertinent information. But of course, the body cam does have, all of that information.
When you say pertinent, pertinent to what exactly?
It would be pertinent to probable cause.
Now, Corporal Leary has already arrested Mr. Turner at this point. He's already in handcuffs out in the hall, right?
Yes. Okay.
Okay. So the decision to take Mr. Turner to jail has basically already been made by Corporal Leary.
I can't say the decision to take him to jail, but definitely the decision to detain him.
Now, I have two instances. I believe I viewed two instances in the video where Miss Behringer says, I didn't want him to leave. Do you remember that?
I don't remember exact verbiage.
Do you remember one instance where she says, I just didn't want to be alone. I don't like traveling. I don't like flying. Do you remember that?
Not verbatim, sir.
And then one instance where she says, I wouldn't let him leave because I didn't want to be alone. I should have let him leave. I should have. Do you remember that?
No, sir, not verbatim.
So let's assume that she did say those words, that she did utter those words, that I wouldn't let him leave because I didn't want to be alone. I should have let him leave.
Your Honor, I would object to any assumptions being made. He stated that he does not recall verbatim.
Let me hear the question. Go ahead, ask the question.
Would a follow-up question to that statement be, if you're conducting an investigation? Well, he's still here. So, Ms. Berenger, how did you prevent him from leaving? Would that be a reasonable follow-up question to ask?
Okay, I'm gonna agree with Ms. Waldrop. That does call for too much speculation. Either rephrase the question or ask him something else. Let's move forward.
Did you have an opportunity to ask Ms. Berenger if she had done anything to prevent Mr. Turner from leaving?
I do not recall, the exact questions that I asked Ms. Berenger.
Was this hotel room, do you remember, did you have to go up the elevator to get there?
Yes,
Okay, so it wasn't on the first floor?
no,
Okay, to your knowledge, was there only one way out of that room?
I believe, if I'm not mistaken, there was a balcony.
Do you think jumping off the balcony is a way out of the room?
I've seen it happen.
Have you ever arrested someone for false imprisonment before?
Your Honor, objection to relevance of whether he's arrested someone on a prior occasion for false imprisonment. That's-
I'll allow it. Go ahead, answer the question if you know.
I don't recall doing so, no, sir.
Do you know what the statute says about false imprisonment?
Vaguely, but of course, I don't have it in front of me.
So the statute 16541, and it says that a person commits the offense of false imprisonment when in violation of the personal liberty of another, he or she arrests, confines, or detains such person without legal authority. So it's a arrest, confine, or detain. So it doesn't have to just be an arrest. It can be confined or detained without legal authority. And so I guess I'd like to focus on the word confine, because if Ms. Berenger did in fact say that she wouldn't let Mr. Turner leave, is it possible that she confined him to that room?
I suppose it could be possible.
And do you know false imprisonment, is that a misdemeanor or a felony?
I don't know off the top of my head.
Do you remember Ms. Berenger actually, she apologized to you guys a number of times? Do you remember that? Said she was sorry?
I remember her being distraught. I think I remember her possibly saying that she was sorry. Now, was it exactly to us? I couldn't say for certain.
Now, according to your report, you only asked Joshua one question, and that was really when he first came to the door. Is that accurate?
According to the report, yes, I only asked him about the blood on his pants.
And he said something about Ms. Berenger getting a nosebleed. Is that accurate?
That is what I recall from the report, yes.
And you didn't ask him any other questions?
Pertaining to the situation, I do not recall doing so.
Did I see Officer Davis out in the hallway with you guys?
You did. She was, as
Is she still out there?
far as I know, yes.
All right, I have no further questions.
Small drop.
Officer Smith, how long was it that you worked at East Point Police Department?
At that time, it was approximately 3 years, ma'am.
Okay. And your title was police officer?
Yes, ma'am.
Okay. And what were your duties as a police officer?
At that time, I was a patrol officer. My duties were to patrol my assigned area, to suppress crime, to answer calls for service.
Okay. And in answering calls for service, did you have the opportunity to respond to domestic violence calls?
Yes, ma'am.
Okay. And as a result of responding to those calls, did you have the opportunity to investigate cases of domestic violence?
Yes, ma'am, on numerous times.
Okay. And as part of your training and experience in investigating domestic violence cases, are you familiar with the terms primary and dominant aggressor?
I am, ma'am, yes.
Okay. Can you explain those for the court?
Yes, in general, the primary aggressor is normally the individual that is, for lack of a better term, the most aggressive, the most dominant one. And at times it will, it can be determined statute ability, and so on and so forth.
And in those previous domestic violence cases that you had the opportunity to investigate, did you make determinations of primary or dominant aggressor?
Yes, ma'am.
Okay. And can you tell the court the steps that you go through in investigating such a crime?
In general, we will normally separate the individuals. One of the main reasons for that is to understand each story, also give them the opportunity to explain themselves, as well as separate the two so that neither one of them feels intimidated by the other. We will generally establish the primary aggressor. And once upon establishing probable cause, we'll make an arrest if arrest needs to be made.
Okay. Were you post-certified in all of 2019?
Say one more time, I'm
Were you
sorry.
post-certified in all of 2019?
Yes, ma'am.
Okay. And on March 14, 2019, do you recall responding to 1380 Virginia Avenue?
Yes, ma'am.
And what is that location?
That is the Holiday Inn, ma'am.
Okay. And is that squarely within the bounds of Fulton County?
It absolutely is.
And how were you made aware of the need to respond to that location?
I received a call for service via police radio.
Okay. And what was that call in reference to?
I believe it was in reference to a fight call.
Okay. And when you arrived on scene, where did you report to?
The first place I stopped once I got on scene was the front desk.
Okay. And what were you informed?
I was informed that that a room had upstairs had called down to the front desk, stating that an adjacent room they heard what sounded like physical altercation. They stated, I believe, in that that the person that they spoke with in the adjacent room stated that
Objection,
someone.
Your Honor, this is hearsay within hearsay.
I'm gonna allow it. I'm gonna allow it. Keep going.
Go ahead, officer.
They stated that that someone had said they heard a female voice say, "Why did you?"
Okay. And from there, where did you go from the front desk?
From there, I went upstairs to the room.
And did you knock on the door to the room?
I did.
Okay. And who answered the door?
Mr. Turner, if I recall correctly.
Okay. And what did you first notice about Mr. Turner?
I noticed the blood on his pants.
Okay. And does this begin your preliminary investigation into what occurred at this room?
Yes, ma'am.
Okay. And what did you ask Mr. Turner, if anything?
I asked from the report, I recall that I asked him whose blood was it and how did it get there?
Okay. And what was his response?
He told me that it was who I learned to be Miss Behringer's blood, and that that she got frequent nosebleeds, and that he was trying to help her stop it.
Okay. At that point, did he tell you anything about Ms. Behringer not allowing him to leave that hotel?
No, ma'am.
At that point, did he tell you anything about any injuries that he had on his person?
Not to my recollection.
And other than the blood on his pants that he attributed to Ms. Behringer, did you see any injuries on Mr. Turner's person?
To my recollection, no, ma'am.
Okay. What did you do next?
After I spoke with Mr. Turner briefly, I went into the room to speak with Ms. Behringer.
Okay.
Okay, after I spoke with her briefly, I know that my backup had arrived. I asked Officer Leary to go into the room to speak with her, which is a normal practice that I've used.
Okay. You went into the room to speak with Ms. Behringer,
Yes,
correct? What was that conversation? What did she inform you?
At the time, I believe she corroborated Mr. Turner's story.
In your experience investigating domestic violence calls and cases, is it typical for victims to corroborate the story of the person of their abuser?
It's highly normal, yes.
Okay. So at this point, you stated that Corporal Leary arrived, is that correct?
Yes, ma'am.
Okay, and you told him to speak with who?
I told him to speak with Ms. Behringer.
Okay. At the time that you were speaking with Ms. Behringer, where was Mr. Turner? Where was the defendant?
He was out, Mr. Turner was outside of the room,
Okay,
on the outside door.
okay. And did he go outside of the door willingly?
Yes,
Okay. And what did you do after telling Corporal Leary to speak with Ms. Behringer?
I stepped outside in the hallway and stood with Mr. Turner.
Okay. At that point, was the defendant in handcuffs at all?
No, ma'am.
Okay. Is this, at the point that you're speaking with him outside of the room, is this still a part of your preliminary investigation into what occurred?
Yes, ma'am.
Okay. And while you were speaking with him, what did he state to you?
I don't recall any particular conversation. I think it was mainly small talk, so I don't recall any specifics to what he said.
So you don't recall him saying anything about what had happened earlier?
No, ma'am.
Okay. And had he said anything further about the incident that you were called there for, you would have notated that in your report, is that correct?
Yes, ma'am.
Okay. What happened next?
After Officer Leary spoke with, excuse me, Mr. Turner, as he came out, and I believe we spoke briefly, I went in to speak with her again to
Okay.
get the rest of the story.
Okay. Tell me what the defendant's demeanor was.
He didn't seem to be at the time. I'm sure that he was nervous. I mean, I vaguely remember a conversation of him not getting along with officers, which is, I've heard that many times, so understood.
Okay. And what was the demeanor of Ms. Behringer when you spoke with her?
I said she seemed to be very upset, somewhat distraught.
Okay. So you stated that you and Corporal Leary had a discussion before you went back in and spoke with Ms. Behringer again, is that correct?
It would be extremely brief in passing.
Okay. And do you recall the nature of the conversation?
He just said that I need to go back in to get the rest of the story.
Okay. And did you do that?
Yes, ma'am.
Okay. And what did you learn?
I learned from that next conversation with Ms. Behringer that as I wrote in my report that according to her, Mr. Turner had grabbed her, shook her. I did notice that she had marks on both of her arms and her ear, if I'm not mistaken.
Okay. Did you notice any bleeding from Ms. Behringer?
I believe that there was redness beneath her nose.
Okay, did it appear to be blood to you?
Yes, ma'am.
Okay, and did you describe that as blood in your police report?
I believe I did, yes.
Okay. And did she specifically state how it was that she got that injury?
According to what I remember, and the police report, that she was shaken, and in that process, she would have, as a result of that, fallen and hit her face on the headboard.
Do you recall whether she told you she had fallen or whether or not he had pushed her into the bed frame?
I do not remember the exact verbiage.
Okay, you just know that she got the injury from hitting the bed frame, is that correct?
Yes, ma'am.
Okay. When you were speaking with the defendant, did he tell you at any point that Ms. Behringer would not let him leave the hotel room?
Not to my recollection.
Okay. Did Ms. Behringer ever tell you that she was preventing him from leaving the hotel room?
I do not recall her using those words, no, ma'am.
Okay. And when you were speaking with the defendant, did he ever make any attempts to show you any injuries that he may have had?
Not to my recollection.
And did he tell you that he had any injuries?
I don't recall him doing so.
Okay. And did you find any probable cause whatsoever to charge Ms. Behringer with anything, any crime,
I did not at the time, no, ma'am.
specifically false imprisonment?
No, ma'am.
And you mentioned that you spoke with the defendant out in the hallway, is that correct?
Yes, ma'am.
Okay. Did you ask him to step out?
I believe I did, which would be a standard procedure to separate, those who are suspected of, being in a physical altercation.
Okay, so that's part of the steps that you talked about earlier when you investigate domestic violence.
Yes,
cases?
ma'am.
Okay, and did he willingly and of his own free will step into the hallway to speak with you?
Yes, he did.
Okay, and at that time, was the defendant under arrest at all?
No, ma'am.
Was the defendant in handcuffs at all?
No, ma'am.
Okay, and that interaction, I believe you stated was part of a preliminary investigation to find out what was going on. Is that correct?
Yes, ma'am.
Okay. And did he ever tell you he didn't want to speak with you?
No, ma'am.
Okay. Did he ever tell you he didn't want to come out into the hallway?
No, ma'am.
Okay. And could he have declined to speak with you?
Absolutely.
Okay. And was the defendant ever removed by officers from the room?
From the room?
Was
No,
he ever
ma'am.
removed
No, ma'am.
by officers?
No, it was not physically removed from the room. No,
Okay. And were there any other officers present while you were speaking with the defendant?
not initially. No, ma'am.
But there was one that arrived on scene, is that correct?
Officer Leary arrived shortly after I did.
Okay. How long had you been speaking with the defendant when Officer Leary arrived?
I would say no more than 5 minutes.
Okay, and how long was he there before he went in and spoke to Ms. Behringer?
It would almost have been immediately.
Okay, and so that left you and the defendant in the hallway to speak, is that correct?
Yes, ma'am.
Okay. How many officers total responded to the scene?
It would have been 3 total.
Okay. Did you ever threaten the defendant if he didn't speak with you?
No, ma'am.
Did you ever make any threats of violence towards the defendant?
Ma'am.
Do you ever have to use violence to subdue the defendant?
No, ma'am.
The statements that the defendant made to you, would you classify those as incriminating at all?
No,
Okay.
no.
At what point, well, let me ask this, did you find probable cause to arrest the defendant?
Yes.
Okay, and what did you base that probable cause on?
It would have been based on the initial call for service. my conversation with the desk attendant, what was heard within the room, the blood on the pants, the physical redness on Miss Behringer's shoulders and face.
Okay, and was there also a security guard that was present from the hotel?
There was.
You have an opportunity to speak with him?
I did as I knocked on the door, he was actually giving me information because he had been up at the room. He was there prior to me getting there.
Mhm.
And I believe he had had interaction with the two prior to me arriving.
Okay, what did he indicate to you?
Objection, hearsay.
No, not her
I'm
saying-
gonna allow it. Go ahead.
He stated that he saw the Miss Behringer get up off the floor and go into the restroom.
Okay. At this point, was the defendant arrested?
Which point is that?
At what point was he arrested?
Oh, sorry, at what point? That was after Officer Leary had spoken with Miss Behringer.
Okay. And did Officer Leary indicate to you that Miss Behringer's story had changed?
Yes,
Okay. And after you arrested the defendant, did you search him?
he was searched instant to arrest, yes, prior to being transported, yes, ma'am.
Okay. And is that just standard procedure?
Yes, ma'am.
Okay. One moment. Nothing further. Judge.
You have further questions?
I do, Judge.
Please make them brief. I think I've got this, and then I'm gonna give you both some instructions. Go ahead.
Officer Smith, you were talking about your protocol for investigating these domestic violence situations.
Sir.
And one of the things that you said was that one of your jobs is to understand each story. Do you remember that?
That's correct.
Okay. Now, are you supposed to do that before you make the arrest of the person?
We generally do that prior to arrest, yes.
In this case, however, there were no questions asked of Mr. Turner prior to him being arrested, though, were there?
Well, I asked him a question in reference to the blood on his pants. Absolutely. Other than that, like I said, I don't recall any other questions that I personally asked him.
Okay. And you also indicated that it's very typical of a victim to corroborate the story of the abuser, right?
Yes.
Okay. And Mr. Turner, when you first talked to him, he told you this story that Miss Behringer just gets these
Nosebleeds.
nosebleeds. Now you said you engaged in a lot of small talk out in the hallway with Mr. Turner.
I didn't say a lot, but we probably did engage in small talk. Yes, sir.
Okay. Did you smell any alcohol coming off Mr. Turner?
To my recollection, I can't say yes or no.
Did he appear intoxicated to you?
Not to my recollection.
Is that something that you would have noted in your report if the perpetrator of a crime you just arrested appeared to be intoxicated?
It's most likely yes.
All right. I have no other questions. Thank you.
All right. Mr. Cornell, you have other witnesses you intend to call?
Judge, if the state will stipulate to the admissibility of Officer Davis's video, because I have them all on one CD, then I don't have to call her in to authenticate it.
Okay, Ms. Waldrop, your response?
No, Judge, I will not. And I think we already had this conversation earlier that the videos would be used for first reading.
Okay, I think I have more than enough information before me to decide the motion from immunity, the motions in limine as it pertains to the iPad incident information and as to the prior issues between the parties. What I would like to hear the parties, I'm gonna ask that both parties send me proposed orders. I do need to do a little bit of research before I rule. I will not rule on those today. I will take those under advisement. I would like to hear about the statement regarding Ms. Pugh, however.
Yes, Your Honor, and I was going to say, in an effort to save time, we could do that particular motion prior to trial. It shouldn't take long.
Okay, but, so you don't wish for us to discuss that today?
We don't have to, Judge.
All right. If you want to go ahead and bring, since the state is taking the same position regarding the admissibility of her, testimony, if you want to bring in Officer Davis, we can do so. Would you like to do that, Mr. Carnell?
Yes, I would, Judge.
All right, so then that will be the end, and then I'm like, oh, I'm losing my words. Again, as I indicated, I'm gonna direct, we have what, 4 motions pending? So for now, we're not gonna rule on, what is it? Sorry, they're not in any particular order here. I'm gonna ask for proposed orders from the parties as it pertains to motion for immunity, the motion in limine regarding the iPad videos. We're not gonna rule on the one regarding witness Tamiko Pugh. That will be handled right before trial. And I'm still gonna ask for the parties to submit me a proposed order as it pertains to the admissibility of the incidents happening on June the 20th. I believe 2 subsequent ones in July of 2020 and September of 2020. But we can go ahead and get testimony from Ms. Davis. And also please submit a proposed order as it pertains to the motion to suppress. All right? And Ms. Davis can come in. Officer Smith, thank you.
All right, you're welcome. Am I dismissed?
You are. Thank you.
Judge Williams, I'm sorry, while they're bringing the other witness in, I need to run to the restroom real quick.
Okay.
Yes.
And while we're waiting, I know we're not on the record. Ms. Waldrop, will you put the state's offer again onto the record as well as Mrs. Turner's history?
Yeah, sure, Judge. Just one moment, please. Yes, Judge, the state would be asking for 12 months. Did you want me?
I just want to know what it is myself. Go ahead.
Yes, Judge. 12 months, balance probated for the defendant while on probation to complete the domestic violence intervention program and have no further contact with Casey Behringer. That is a pretrial offer, Judge. The state would object to the use of first offender.
All right. And for the history? Okay, my Odyssey has shut itself down entirely again. Okay. All right, I'm sorry, Ms. Waldrop, does he have any history?
Your Honor, I show this as a first arrest in Georgia per his GCIC.
Okay, first arrest in Georgia, or first arrest period
Your Honor, I only show a GCIC. So
for
first
Georgia?
arrest.
Okay,
Oh, I need my glasses.
all right.
Mm. Good morning, afternoon.
Yes, it's definitely afternoon. Please state your name, ma'am.
Kimberly Davis.
All right, Ms. Davis, please raise your right hand so you can be sworn.
Swear from testimony not given the case to be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon. Is it Officer Davis?
Sergeant.
Sergeant Davis. I'm Attorney Jason Carnell. Were you with the East Point Police Department back on March 14th of 2019?
Yes,
And did you happen to respond to a call with Sergeant Smith and Corporal Leary at the time in a hotel room that night?
yes,
And is that the same incident where Mr. Turner was arrested?
from what I'm being told, I haven't seen anything or looked at anything on this case since 20.
Okay. All right. Did you have a body cam active at the time?
I'm assuming so.
And would you recognize your footage if I showed it to you?
I will recognize my voice. I won't be on it probably, but
Okay.
I'm sure I
Permission to
recognize
approach
my-
the witness, Judge?
Yes, permission so granted.
Let me go ahead and fast forward to where you're
Thank you.
talking.
Oh, yeah, that's familiar.
Is that your voice?
Mhm.
Okay. All right, and so is that Mr. Turner there in the video?
I'm assuming it is, yes.
Do you believe that this is your video from that night?
Yeah, sounds like me.
Okay. And then for some reason that there were two videos. And it looks like the second one starts here.
Mhm. That's me.
All right.
So both of these are your videos from that night?
Mhm.
All right, Judge, I'll move to admit these videos into evidence.
And again, we've agreed today for the purposes of this motion hearing that we're gonna have Sergeant Davis testify. And to the extent that she cannot recall, we'll allow you to introduce the videos. Please proceed with your line of questioning.
I have no other questions, Judge.
All right. Any questions, Ms. Waltrop?
No, Judge. not for
All
me.
right. Would you all like to make brief closing statements for me today?
Of course, Judge.
Or do you still wish to have Mr. Turner come back?
No, Judge, I don't need to recall Mr. Turner.
Okay, Sergeant Davis, thank you.
Well, okay, thank you.
That was simple.
That's simple.
All right.
You were trying to find an officer because of the radio?
And again, I'm asking for proposed orders on 4 motions, and the 5th will be considered. Do we already have a jury trial date for this?
No, we don't, Judge.
Okay, let's. It's gonna be December 11th. All right. Please proceed. Mr. Turner. You can take that, yes, thank you.
You ready, Judge?
I hope I am after today. Please proceed.
Think that's up to the judge?
Well,
Okay.
you want to wait?
No, yeah, I'll hang on to him for now. Maybe I'll refer to him. Now, Judge, in the interest of saving the court some time today, I've opted not to play the videos for the court. I would ask that the court watch these videos in chambers and give them the attention that I've given them in preparing for the case today. Now I'm going to go over quite a bit of what these videos say. Obviously, it was very difficult with the speaker on my laptop for Officer Leary to hear a lot of the stuff that was being said.
Understood.
I didn't bother doing it with Sergeant Smith because I basically knew that we were going to have the same problem.
And Judge, I would just ask that it be limited to what was refreshed with regard to recollection, because as you know, the videos were not introduced into evidence. So.
Do you all have pending motions in limine regarding the admissibility of the dash cam video at trial?
No, we don't, Judge.
Okay, I was just curious. All right, continue, Mr. Cornell.
Judge, for the most part, stereotyping is very frowned upon in our society. If you stereotype based on race or ethnicity, you're persona non grata. But certain stereotypes won't die. And one of those stereotypes is when the police arrive and they see what they deem to be a poor, helpless female, they automatically assume that you have a situation of an abusive boyfriend. When the police come to the scene of a domestic violence complaint with that stereotype in mind, you get the type of investigation that we had in March of 2019. There is every bit of evidence to suggest that Mr. Turner was trying to leave that room. There are 5 instances in the 2 videos, 2 to Corporal Leary and 3 to Sergeant Smith, where Miss Behringer says, I didn't want him to leave. And the last time she says it, she says specifically, I wouldn't let him leave. Those are her words. I can tell you the timestamp in the video when she says it. Miss Behringer repeatedly tells, well, let me back up for a second, Judge. The reason, of course, I introduced the video footage, the pictures, is to show that this is defendants 2 and defendants 3. These are the pictures of Mr. Turner standing out in the hallway. He's got his hoodie sweater on and his shoes. And if you watch the video, Miss Behringer's wearing a tank top and socks. Mr. Turner was trying to leave. He was ready to leave. It's 3 o'clock in the morning, for God's sake. And she's ready for bed. He's fully dressed and ready to leave. And she tells the police 5 times she didn't want him to leave, with the culmination being when she specifically says, I wouldn't let him leave. And the police don't ask a single question about this. Now, if you're not stereotyping and you haven't made up your mind as to who the victim is and who the perpetrator is, the natural question to ask in response to that would obviously be, what did you do to prevent him from leaving? But of course, when she says it, Mr. Turner's already out in the hallway in handcuffs. He's already been arrested when she tells Sergeant Smith that she wouldn't let him leave. So the decision's already been made. That's why there was never any investigation into what Miss Behringer did, because the decision to arrest Mr. Turner happened like that. And it's obvious from the videos within 6 minutes of Corporal Leary getting there. Remember, Miss Behringer hasn't really said a thing to Sergeant Smith. He comes out of the room, Corporal Leary goes in 6 minutes, he's out with Mr. Turner in handcuffs. Corporal Leary hasn't asked Mr. Turner a question either, not a single question at that point, and he's already in handcuffs. What was it Sergeant Smith said about you're supposed to get both sides of the story to establish probable cause? There was no side to Mr. Turner's story. He was not allowed to give his side to the story. He wasn't asked any questions. Well, okay, man, what's your version before being put in handcuffs? Just from her statements alone, her statements in the video, there's reasonable suspicion that she's committed a crime. What crime? The crime of false imprisonment. I've read the statute a number of times. Your Honor's familiar with the law. After he's under arrest and he's standing out in the hall, and again, Judge, this is on video. I'm telling you, man, I didn't put my hands on her. I didn't. I was just trying to leave. Which is completely consistent with what Miss Behringer had been saying inside the room. I didn't want him to leave. I wouldn't let him leave. And then out in the hall, what's Joshua saying? I was just trying to leave. Corporal Leary says, so why didn't you leave? She got in the way. Corporal Leary then says, and you moved her too. Joshua says, I just tried to help her out of the way. I didn't pick her up. I didn't hurt her. And then Corporal Leary said sarcastically, okay. I tried to help her out of the way of the door, and she grabbed me, and that was it. And we went down on the bed. And this is completely consistent with what she said. Now, Judge, as I said in my opening, a victim of false imprisonment has the right to defend against the violation of his or her liberty. And that is from Glenn v. State, 849 Southeast 2nd, 409. It's a 2020 case. And of course, under 16.321, Joshua is justified in using force to the extent that he reasonably believes it's necessary to defend himself. The legal standard for the court to decide an immunity motion based on self-defense is more probably than not. So obviously just a little better than 50%. If you give the word of my client equal weight to the word of Ms. Barringer, if that's all we do here today, then the circumstantial evidence of what Ms. Barringer says and what Mr. Turner says in the hallway should be sufficient to bring us to the more probably than not standard. It's 3 a.m. Ms. Barringer admits she's having a panic attack. She tells the officers multiple times about her panic attack. She's not dressed, he is. She tells the officers she wouldn't let him leave. He told the officers, he's told the court today that he was trying to leave. They asked if he hit her. They asked her if he had hit her. She says no. They ask her about the bloody nose. She points to the bed. At the same time, outside the room, he's telling this to Corporal Leary. There's only one way this went down, Judge. She wouldn't let him leave. Now, Judge, we had our sidebar where we were discussing the bed, and I showed the court the picture of the bed. Ms. Barringer specifically said that she was trying to go to bed. She got in that bed. And then she let Joshua into the room. He tried to get out on the balcony. She pulled him back inside, and then he dumped her stuff out on the bed. That bed, and that's Officer Davis's video. That's about 6.
Your Honor, at this point, I would object. This is facts, not in evidence, something that he showed you when we approached. None of that is in evidence.
All right, sustain, continue, Mr. Cornell.
Judge, the videos are in evidence. I've
Oh,
tendered the
they're not.
videos into evidence.
They have not been tendered into evidence.
Just continue. Understood. But I'm gonna agree with Ms. Waldrop, they have not been tendered.
Judge, I tendered these videos into evidence.
Only for the extent that we're refreshing our witnesses.
Well, Judge, that was,
If we want to re-argue that point, we can do that quickly. We would like to hold a brief argument regarding the videos in their entirety.
yes,
Might
Judge.
be appropriate.
Yes, Judge. I
All right,
tend.
let's go through that. We spoke about it briefly, but I think that's gonna be a sticking point, and it probably needs to be on the record. All right, let's shift gears very briefly. Mr. Cornell, make your argument as to why all 3 videos should be admitted. We'll allow Ms. Waldrop to respond, and then we'll go from there. All right, and then we'll make a ruling regarding the complete admissibility of all 3 dash cam videos. All right?
Judge, I tendered all 3 videos into evidence. They were all 3 identified by the officers who made them. They depict the investigation that was conducted by all 3 officers, and the fact finder in this case should make a decision based on all the evidence.
Ms. Waldrop, your response.
Your Honor, not only did we agree beforehand that the videos would be cumulative and duplicative because we had officer testimony here. And so we agreed that in the event that they could not recall something, the video may be used to refresh their recollection. But in addition to that, Your Honor, there was not a properly laid foundation, official foundation for the videos. You did not rule on their admissibility in terms of evidence. They were not tendered. And again, they were duplicative and cumulative. The officers were here to testify, and there was no proper foundation. And that's the reason why the duplicativeness of the videos is why we decided that they would only be used to refresh recollection. So they have not been tendered into evidence, Judge.
All right. Throughout the hearing today, we allowed certain portions of the video to be viewed by myself and a part of the official record for the purposes of refreshing the officers. Because there is some question, and I do believe the entire portions of those dash cam videos will be relevant. I will review them as part of granting these motions, but separate discussion should take place before trial as to their admissibility. All right, I'm gonna review them myself. But whether or not they'll be admitted to trial, I'll allow the judge who sits at trial to.
Your Honor, I do just want to say on the record, the officers did not testify as to the entire video being an accurate representation of what occurred. What they testified to was the snippet that the defense counsel showed them to refresh their recollection. So I would ask that they not be.
I note your objection, but they did testify that those were their dash cam videos, so I'm gonna review them myself. Again, you can re-raise that prior to trial before the judge who actually holds the trial that day, okay? All right, continue, Mr. Cornell, very
Thank you, Judge.
briefly. I think I've got this.
Thank you, Judge. There's excuse me. As I was stating, Judge, there's one way this went down. And I think, Your Honor, you will get the sense of that from watching the videos. I would also like to offer to both the prosecution and to Your Honor, the transcripts that I've created as an aid. I believe that these are admissible, not as evidence, but as an aid to the.
I'll watch the videos as is, Mr. Cornell, and think that'll be sufficient, all right?
Okay, Judge. Well, as I was stating, Mr. Turner is allowed to defend himself, and he's allowed to defend against the violation of his personal freedom when Ms. Behringer stood in front of the door and wouldn't let him leave. You can stop right there and grant him immunity from prosecution. But then, as he indicated, he tried to get past her, and she jumped on him, and he fell backwards onto the folding bed that was right next to the door. Mr. Turner offered to show Corporal Leary the red marks on him from this encounter, and he was ignored. This was not an investigation, Judge. From the minute the officers got there, they had already made up their minds, specifically Corporal Leary, as to who he was going to arrest. And I think that you will get the same impression from watching just the 6 minutes of this video prior to making the arrest. And that's all I have, Judge.
Thank you, Ms. Waldrop.
Yes, Judge, I would ask that you deny the defendant's motion for immunity on grounds that there's more than sufficient evidence to show that the defendant was not acting in self-defense, that he was not justified in committing the offense of simple battery with which he is charged against Ms. Casey Behringer on March 14th of 2019. There are several conflicts in evidence in this case that make it appropriate for a jury to make the ultimate determination. Your Honor, you heard testimony from Ms. Behringer as to what occurred. You heard testimony from her that she sustained injuries that included a bloody nose, marks on her arms, and that the defendant not only pushed her and struck her, but also slammed her into the bed frame, causing her to actually break the bed frame. You heard testimony from Ms. Behringer as to why it is that she told the officers that she initially corroborated the defendant's story regarding this nosebleed. And she was very clear that she was scared, that this was a controlling relationship in which she was manipulated, isolated, and felt completely and totally frightened of the defendant. You heard testimony from Detective Leary, who stated that the defendant never told him anything about Ms. Behringer not allowing him to leave. Defense counsel played audio stating that Ms. Behringer wanted the defendant to stay. She even testified to that because she was concerned not only for his safety, but for the safety of other people. And so she did not want him to leave and then drive and then potentially put people at risk. But there was no testimony from any of the officers, Detective Leary or Officer Smith, that the defendant had indicated to them that he was the victim of the crime of false imprisonment. They both testified that there was no evidence and that they found no probable cause for that particular charge. And in fact, Ms. Behringer was never charged with anything as a result of this incident. Your Honor, there was testimony from both Detective Leary and Officer Smith that they observed visible injury on Ms. Behringer, and that injury was consistent with her truthful story that she finally revealed to them after she had an opportunity to speak with Detective Leary away from the defendant. Your Honor, with respect to the defendant's claims of false imprisonment and why that is somehow justification for the acts that occurred on this particular day, the defendant himself never told the officers that Ms. Behringer prevented him from leaving. He never showed them any marks or injuries that he had to his person as a result of Ms. Behringer. He testified that she had jumped on him, and he never said any of that to the officers, despite being the first one that opened that door to them and had the first opportunity to tell them what was going on. He spoke with not just Officer Smith initially when he opened the door, but then Officer Leary as well, and never said anything of the sort to either one of them. He was the only one with blood on him, and that blood was from Ms. Behringer by the defendant's own admission. So, Your Honor, I think there is more than enough evidence to show that the defendant was not acting in self-defense. I think there is more than enough conflicts in the evidence that this should be presented to a jury and that you should deny the defendant's motion for immunity. And Your Honor, with respect to those subsequent incidents that the defendant referenced, those are not justification for what happened a year and a half or so earlier. And so there really is no defense in this particular case or justification for the commission of the simple battery against Ms. Behringer, and I would ask you to deny the motion.
All right. Thank you both. Again, I'm gonna take these under advisement. There's one thing I want to look up. I am gonna look at those videos briefly. And if you would send those proposed orders in Word to Ms. Bolton, I will get those issued no later. I'm gonna ask that you send them no later than, we have a long weekend, so let me see. I would normally say send them by Monday, but in light of people's holiday travels, I'm gonna ask for proposed orders by Wednesday, September 6th. Please send those to Ms. Bolton for my signature. That should give me time to review everything and look up a few things I'd like to take a look at. All right?
You're asking for the orders by the 6th?
Yes.
Okay.
Is that gonna present an undue hardship?
Well, Your Honor, I would just ask for that Friday.
You need more time? That's fine.
Okay.
That's fine. You can get them to me by Friday, the 8th.
Okay.
All right? Does that give you enough time as well, Mr. Cornell?
Yes, it does, Judge.
All
Thank
right.
you.
Thank you all for your patience today. And I promise I will rule on these as soon as I get those orders in. All right?
I think we should be thanking you for your patience, Judge.
All right. It was a fun day, wasn't it? And I do encourage the parties to continue to discuss this. I know that you said that you've reached an impasse, but I do see some challenges to both sides' arguments. So I think it would benefit both parties to continue the pre-tripart process. All right?
Understood, Judge.
All right. Thank you. And I encourage you as well, Ms. Waldrop. I hope that you will take the court's recommendation that you continue to try to work this case out as well. If not, we will all be again here at the December 11th jury trial date.
I'm sorry, Judge, December 11th?
Yes, that's the date this case will be set for jury trial.
And is that's an actual, is that a trial date or?
As far as I know, yes, that's the actual trial date.
Judge, I'm sure the state agrees, if we do proceed to trial, we're going to need a special set date because both the defendant and the alleged victim in the case live in New Hampshire.
Okay, so December 11th doesn't give them enough sufficient notice if I'm telling them now?
Oh, well, I'm sorry, Judge, it does. I just didn't know if we're going to be in a room full of other cases and.
Oh, I see what you're saying.
Call someone else.
Let me see, Miss Bolton, would that still be the date or would they need a specialist? So should we put them on that Friday to make sure that they're by themselves?
Okay, so if we're gonna discuss, another motion. Okay, so if, usually motions are taken up before,
No, what I'm saying is if they're actually, I'm trying to give them their actual jury trial date.
it's a compiled list.
It'll be everybody on
Yes.
one day, so that's not gonna work for them, is what they're saying, because they'll have to come from out of town. So what they're hoping for is a day that, like, kind of like today, where they're completely by themselves. And then if the case proceeds to jury trial, it can go ahead and happen that day, is what my understanding is. Is that correct? Is that what you all are asking?
Yes, sir, I believe that the
Yes,
11th may be
Judge.
calendar call, so nothing,
Yeah, nothing would happen there,
and then I don't think we have jurors on Friday.
right? Not always.
Okay, so.
We may have to, we won't have that information today, it sounds like. We'll
Okay.
have to let you know, and then we'll put in that the parties don't live here. And we need a specially set date. So it's gonna take us a minute to figure out when you'll come back.
Do
But
we,
it
need-
will be in December more than likely.
do we need to file a motion for a special set date, Judge, or is this
I don't bel-
conversation good?
Ms. Bolton, what do you think? I think I've known the clerks to be excellent and to note everything that needs to be noted. If you're very concerned, you can, but I think that Ms. Bolton understands the complexity of your case and situation and will set you. Is Ms. James also on the line listening?
No, yeah.
Oh, okay.
So what I'll do is, so I'm gonna email you. So you-
The court reporter has her hand up. I don't know.
Okay, Ms. Howard?
I just have a couple of clarifications I need before everyone leaves. One is I will need the exhibits that were admitted, the photos. And I don't know how you'd like to do that. You can scan and email them to me at my Fulton County email if you'd like. Or if there's someone there that can retain them, I can come pick them up on Tuesday.
Yes, Ms. Howard, did you check your email? I sent you an email earlier.
Oh,
Probably.
haven't checked my email, sorry.
So, yeah, I actually discussed that, in the email that I sent you earlier
Okay,
about the evidence.
okay. And could you just spell a couple of people's names for me? The Tom, I couldn't tell what his last name was, Bad or,
The alleged married individual.
I'm sorry, it's Bab, B-A-B-B.
Oh, I thought his name was Bad. Okay.
and Miss Behringer's first name, how's it spelled?
Casey, Casey.
Okay. And then, I'm sorry, it's just a few people that you mentioned. I don't have I don't know who this, was it Tamika's Hugh?
Tamika Pugh,
Can you spell that? I can't understand that.
Tamiko, Pugh, P-U-G-H.
Okay. And then the last one was the neighbor where they lived, Rhonda. Something was her last name. I didn't get her last name. It was mentioned if you know it, but,
Yeah, I think I have that.
and also the case that you mentioned in your closing was a 2020 case, something the state, I didn't get it.
Glenn versus State.
Glenn? Okay,
Mhm.
It looks like the name is Donna Babrick or Babkirk. B-A-B-K-I-R-K, Donna Babkirk.
Badkirk. Okay,
Yeah.
sorry.
BAB.
B is in boy.
Oh, BAB.
Yeah, B is in boy, A is in alpha, B is in boy.
Sorry
And
about that.
then like Captain Kirk.
Gotcha. Thank you. Sorry, I really wish I would have been there in person today. I apologize for the interruptions and thank you, Judge, for,
And can
And
I, I'm sorry,
my-
can I request a transcript? I'd like a copy of the transcript for today.
yes, can you send me an email? As
Sure,
well?
what's your email?
It's Courtney.Howard@FultonCountyGA .gov, and my name is spelled Courtney.
Thank you.
All right, I believe we'll be in recess for now and make sure that all addresses stay current. I know that you'll be in communication, but we want to make sure that you get all notices. All right,
Will do, Judge. Thank you.
all right, take care, everyone.
Thank you.